Okay, how you guys doing today?
Excellent. How about you, Ken?
Great, doing great. Yesterday's mastery training was I got one sent to me, and I was in the June, and then this July, and that was just the best ever. It was a tremendous call yesterday, and I really appreciate it. My questions are when it comes to here in California, if the PR, it's my understanding that if the personal representative has full authority, the court, is that correct?
I don't
The
understand the
offer
question.
doesn't have to be submitted. In other words, if the executor or administrator has full authority, that the offer doesn't have to receive court approval, they can approve it themselves. Is that correct or false?
That's correct, and it's not subject to the overbid process. So think of it as the HOV lane.
Okay. Now, in the cases where there's a limited authority, the BPO, and a BPO needs to occur. Who pays for the BPO, the estate or the investor?
The estate will pay for it. The court will order it.
Okay. And can you explain a little bit more about the overbid process? I submit mine, and is it? I mean, how does that work? Because I don't know anything about it.
So you submit your offer, assuming that the court has appointed a referee and has received evaluation, and that will be presented in the next hearing. When it's presented, the court will give an opportunity to the public to overbid that contract. And I think in California, it's a minimum 10% overbid premium. And then you'll have a chance to overbid that as a member of the public as well. But they can unseat you right there. It really behaves a lot like a trustee sale at that point.
Okay. One more question. Now, I was doing some research trying to learn this thing in California, and they mentioned something called a 4-month creditor's claim period. Do you know anything about that in California?
So when you first open probate, you have a minimum amount of time that you have to, I think it's 3 weeks in California, like most places. You have to publish notice in the newspaper. So typically before they actually have the authority, they're still known as the petitioner. But once probate is filed, that person is known as the petitioner. One of the first things the petitioner needs to do is file notice to creditors in the newspaper for at least 21 days. And then there's a period of time in each state, it can vary, but there's a period of time that notice to the creditor's claims, the notice remains open for creditors to make claims to the court. That's one of the reasons why probate just basically cannot close any quicker than like 7-8 months in your state. Like that is as fast as you'll see one happen. And most of them are taking 9 to 12 months in your state. Part of it is because, families get ugly and cause delays. They don't do what the attorney needs them to do. But part of it is because there just is that open period where you have to be open, the estate has to remain open for creditors' claims.
Wow. Okay. So I need to make sure I'm doing something else in the meantime.
Well, no. Back up. You need to understand that doesn't mean that they can't sell the real estate. That means they can't close the estate or close the probate. So if they have full authority, you can sign a contract the day after the day that they're granted full authority. They can sign a contract with you. You can get that ratified, open escrow, close the deal. And then the funds will be held in the estate's bank account until that period's over, until the final probate accounting, and then they can distribute to the heirs. So the heirs won't get their money, but you can get yours. You can get the house and move on if you meet those certain conditions. So when you get on the phones, you're going to hear this objection. Our probate attorney said we can't do anything until he tells us, or our probate attorney said we can't sell until probate closes. And either that attorney is an idiot or they heard something differently than what he said, and I think the latter is the most common. But a lot of people have this false perception that they can't do anything, and it's simply not true in most cases. So don't sit around waiting because you think you can't do anything. And you're doing the right thing. Like, you're educating yourself on your process, because if they didn't hear the attorney correctly and they're operating off of misinformation, if you come in as a strong leader and say, no, actually, the attorney, we consider them a member of our team. We obviously don't handle the legal aspects, but we certainly understand them. Here's what they should have told you. Does that sound more like what you heard? Okay, I thought so. So in that case, I would like to make you an offer on the home, and then you move forward with your negotiation or setting the appointment or whatever you're doing.
Okay. Last question.